We are recording this video in March of 2024. Why is that relevant? Because we're about 5 months past a jury entering a verdict for $1.8 billion against the National Association of Realtors for alleged antitrust violations. And what was that jury verdict based on? What was the legal hook to tag the National Association of Realtors? Well, in part, it was based on the Realtor Code of Ethics, which raises the question, is it time to think about getting rid of the Realtor Code of Ethics? If you're interested in that topic, keep watching this video. All right, let me explain a little bit more about this. I'll have an analogy for you. Imagine there are Los Angeles Raiders fans who come to Denver, Colorado to watch their beloved football team play the Denver Broncos in Mile High Stadium in Denver, Colorado. And imagine those Raiders fans have a bad experience and they feel abused by the Denver Bronco fans. That would never happen. We have the best fans in the world. But anyway, imagine that these Raiders fans feel that they were abused by the Denver Bronco fans. Well, if they were inclined to file a lawsuit, it would be logical for them to sue the Denver Bronco fans who were doing the abuse. But that's complicated. Who are these people, and which ones were doing it, and were some worse than others, and do they have any money, and do they have any income, and might they file bankruptcy? It would be so much easier to go after the NFL. And that's sort of what these lawsuits are. The plaintiffs in the lawsuits were able to introduce evidence of real estate brokers saying stupid things, leaving stupid voicemail messages, and they had a legal hook to tag the National Association of Realtors for that. Well, what was that legal hook? It was the Realtor Code of Ethics. More specifically, part of it was something called Standard of Practice 16-16, which is part of Article 16 of the Realtor Code of Ethics, for your Realtor Code of Ethics nerds out there, of which I think of myself as one. Well, what does this say? What does the Standard of Practice say? I'm paraphrasing, but Standard Practice 16-16 says that realtors shall not use the terms of an offer, that is, when realtors are working for the buyer's side, shall not use the terms of the offer to purchase a property to attempt to modify the listing broker's offer of compensation identified in the MLS. Well, why is that bad? Imagine there's a buyer out there, and that buyer wants to make their buyer's offer more attractive and call for the listing broker to pay a lower co-op commission to the buyer side broker. Imagine that buyer has negotiated hard with their buyer side broker, who instead of accepting a market commission of this amount, they've negotiated their buyer side broker to accept a reduced amount of co-op commission. The buyer might want to use the terms of the offer to attempt to negotiate down the co-op commission so that savings could be passed on to the seller, so that the net proceeds of the seller are higher, so that buyer's offer would be more likely to be accepted by the seller. But Standard Practice 16-16 prohibits realtors from using the terms of the offer to negotiate down commissions. Does it prohibit negotiation about co-ops? No. It certainly allows the buyer side broker to call up the listing broker and propose this scheme of a lower co-op commission, pass the savings on to the seller, the buyer's offer will be more attractive, blah, blah, blah. But why might it be more advantageous to include the lower commission in the offer? And the reason it's more advantageous is, number one, when the buyer side broker calls the listing broker doesn't know whether the buyer side broker is bluffing or not. When the listing broker sees it in the offer that the buyer's only going to buy if the co-op commission is reduced, the listing broker knows the buyer isn't bluffing. Number two, by putting it in the offer, it essentially forces the listing broker to pass this opportunity on to the seller. The listing broker who just receives the phone call, the attempt to negotiate this before the offer is submitted, may never pass that opportunity on to the seller. So the theory of the lawsuit is standard practice 16. A part of the theory of the lawsuit is standard of practice 16-16 discourages discourages negotiation about co-op commissions. It discourages attempts to lower co-op commissions, which artificially props up the amount of co-op commissions. So the theory goes, which creates higher gross commissions for seller side brokers. So some of you are watching this and scratching your head and saying, well, okay, maybe we need to just revise and delete this standard practice 16-16. Well, that would take care of the problem that we're aware of, but might there be other problems in the Realtor Code of Ethics that we're just not dialed into? And that's the whole point. We don't know. We have blind spots. We have blind spots as individuals. We have blind spots as part of being institutions. And let me just point out that there's been other blind spots. Until the 1950s, there was language in the Code of Ethics that encouraged real estate brokers to continue segregation. That the real estate brokers were not supposed to encourage buyers to buy into properties where it would diminish the value of the properties in the neighborhood in which the buyers were buying. Right now, there is a provision in the Code of Ethics that seems to raise the bar for Colorado brokers. Under Colorado law, brokers are only obligated to disclose facts of which those brokers have actual knowledge. But there's a part of the Code of Ethics, Article 2 of the Code of Ethics, that purports to require realtors to discover and disclose adverse factors reasonably apparent to someone with expertise in their area. That's routinely ignored in Colorado. The higher bar is routinely ignored. Real estate brokers in Colorado are taught that they only have to disclose adverse material facts of which they're aware. So I've given you 3 examples where the Code of Ethics is not quite as perfect or pure as we would like to think it to be. It has the potential to cause mischief. It's worthwhile keeping if it has huge benefits. And when the Realtor Code of Ethics was created, it was way ahead of its time. It was before state regulation. It was before prevalent state regulation. It was very influential in influencing states to raise the bar through regulation. But in the state of Colorado, there's very little daylight. There's very little difference between the Realtor Code of Ethics and state regulation. And whatever daylight there is routinely ignored, raising the question, is this little bit of raising the bar worthwhile? In my opinion, it's not. And at least based on what's going on in Colorado, I have to pretend to have humility about what's going on in other states. I am not an expert about regulation in states outside of Colorado. But I think in states with sophisticated licensing law, and that's a lot of the country, I'm not sure that the Realtor Code of Ethics does more good than harm, and we should think about getting rid of it. All right, thanks for taking it. Thanks for watching this far. Remember, we live in a complicated world. Be careful out there.